Hey guys, John Ween, attorney and legal instructor with Blue to Gold Law Enforcement Training, coming to you today with another roadside chat. Now, today's question is this. If police conduct a traffic stop and tow the vehicle, pursuant to that tow, they perform an inventory within department policy. Are we allowed to search the vehicle completely? The hypothetical is we find a pipe used to smoke illegal substances when conducting the inventory. Do you have to stop and apply for a search warrant? Here is what I'll tell you. In the vast majority of states, the answer is no. Michigan versus Thomas is a 1982 United States Supreme Court case. And in that case, officers stop a vehicle for a traffic infraction when they make contact with the driver and determine that the driver is a 14-year-old operating the vehicle without a driver's license. And in the passenger seat is Thomas. Now, Thomas is what we call a responsible criminal, right? He's actually drinking booze while they're driving around. He's got some malt liquor in his hand. And so to do the right thing, he had the 14-year-old drive. So I commend him on that. Ultimately, they arrest him for possession of an open container, right? They make arrangements for the kid to take the kid out of there and get the kid home. And then they go through and they start performing an inventory of the vehicle pursuant to their policy. And as they're inventorying that vehicle, they find some marijuana in the unlocked glove box. Now, they transition seamlessly from the inventory into a full search of the vehicle. And they go through the vehicle, they go up underneath the dashboard, and they find a .38 caliber revolver stuffed in an air vent underneath the dashboard. And the United States Supreme Court said, cool, right? No issue here. You start doing a valid inventory because you're going to tow that car. You find contraband, you find something illegal, you can then transition seamlessly into a warrantless search, basically under the automobile exception of the warrant requirement here, right? So if you are doing an inventory, a valid inventory, and you find contraband that gives you probable cause that there's additional evidence of a crime inside that vehicle, you can then transition to the Carroll doctrine, transition to the automobile exception, looking anywhere inside there that could contain the contraband for which you have probable cause to believe is inside the car. Exigency is not a requirement. Chambers versus Maroney established this. Texas versus White established this. There is no requirement for exigency under the Carroll doctrine. Here is the caveat. The officer who asked this question is from the great state of Pennsylvania. And Pennsylvania is one of our outlier states. And so if you are in one of those states, like New Mexico, like Pennsylvania, that are far more restrictive under their state standard, it's not enough just to know United States Supreme Court case law. Why? Because in many of these more restrictive states, exigency is a requirement. They do not follow Chambers versus Maroney or any of its progeny under the state law constitution. And so, for the officer who asked this question, for Pennsylvania officers, for those officers who are far more restrictive under their state standard, where exigency is still a requirement, if you are conducting an inventory and then you find evidence of a crime, should you then go get a warrant? The answer is yes, right? If you are conducting that valid inventory, you find evidence and you want to transition into the Carroll doctrine in those states where exigency is a requirement, if you are going to start working under the Carroll doctrine, you need to stop and get a warrant, right? Because exigency is a requirement. Now, while you are conducting that inventory, if you find plain view items, per the letter of the law, those will still be admissible, not under the Carroll doctrine, but under plain view. Commonwealth versus McMahon recognized that even in Pennsylvania, the consent exception, the plain view exception, the inventory search exception, the exigent circumstances exception, the automobile exception, the stop and frisk exception, and the search intent to arrest exception are still factors to consider. And so if you're doing that inventory and you discover plain view evidence, well, that'll still be admissible. The problem is this. Is a court going to believe that if you move past that point and continue conducting that inventory, are you only looking in places where it is reasonable to believe valuables could be hidden? Because if you are not, if you go beyond there, then the court is going to look at your subjective intent and say, hey, this is no longer an inventory. This is a search for an evidentiary purpose. You should have stopped and got a warrant. So best practice is, if you are in those more restrictive states, if you're conducting an inventory and you find contraband, stop and get a warrant. Or continue conducting that inventory with full knowledge that later on a court will question whether or not you were conducting a valid inventory or you were transitioning into an evidentiary search. Because yes, while usually the subjective intent of the officer is irrelevant in such an analysis, Even the United States Supreme Court has recognized that inventory and an administrative search, the subjective intent, what you are actually looking for and what you are actually doing in that car is relevant. I sure hope this helps, guys. If you have any additional questions, please feel free to contact us. Contact me, John, at bluetogold.com. Go to our website, bluetogold.com. Make sure you sign up for our free webinars, and I hope to see you soon. Until next time, be safe out there and make good case law.